Thank you all for coming here today. I just want to say thank you to Matthew for his leadership in the last year, to Deborah and the Senior Management Board, and all at the APIL office, without whom this whole show grinds to a halt. They've been fantastic as always, and I want to acknowledge that. We come together at the tail end of a barrage of reforms and battles which have left lawyers reeling and injured people the losers. But while there are many in politics and in the media, insurance industry, who wish we'd roll over and give up, we will not give up. We haven't given up, and nor will we do so. We stand united because however much they may be maligned or undermined or commoditised, injured people still need our help. As long as people are negligent, others will be injured as a result, and we're in a unique position to help them. Injured people must have an effective voice, and we certainly provide that voice. No commercial incentive can ever be as inspiring. I know that from my own experience. Comparing my role as a legal businessman with my work campaigning on behalf of injured people, I know what I find most motivating and gratifying. Being a member of this organisation is about 100% commitment to injured people. This is what we provide. After all, who else is going to fight for them? It's down to us. We're having to adapt and survive in this tough new environment, but I know everyone in this room is just as dedicated, just as determined to help injured people as ever before. And injured people need us more now than ever before. I'm passionate about the rights of injured people, and I know you feel the same. Sometimes it's easy to forget why we do this. Why we did all those years of training and study, why we specialised. It's easy to get sucked into the business of law, especially when our businesses are threatened. It almost happened to me. When I started out as a trainee, I conducted family work, care proceedings, property, commercial and criminal cases, as well as PI. I got on quite well, and somewhere along the line I realised I'd majored on being a businessman. I became embroiled in ambitious plans for growth and was immersed in that, and so focused on the daily work of making a practice grow that I forgot what really mattered. But then I had an opportunity to rethink, to take stock, and I knew that I wanted to build something more worthwhile. A professional, ethical practice which put the vulnerable, the injured person at its centre. I'm pleased to say that I'm now trying to do that, and doing it not just by focusing on rules and the daily practice of law, but by pouring energy into what is truly professional, what's ethical, and what's right. After all, we all know what is right instinctively, don't we? Politicians, doctors, lawyers, insurers, we all know what's right. What often appears to be difficult or challenging is doing what's right rather than what's simply expedient. So in the next year, we must redouble our efforts to persuade everyone who is involved in developing and delivering legal reform to do the right thing for injured people. Being injured by the avoidable fault of another in itself is bad enough. What injured people need is justice and care. It's their basic right. It's the mark of a civilised society. We must continue to strive for the highest standards possible and in terms of professional experience, so that we can all be the best lawyers we possibly can. And we must never allow ourselves to forget why we do this and what APIL stands for in the first place, the legitimate rights of the injured person. I think we can be forgiven for having developed something of a siege mentality after recent years. I know this is the moment to get out of the bunker and to get back focusing on our own campaign agenda, never neglecting our work to help members and their practices flourish. People talk about rights these days a lot, and that's a good thing. So let's remember that injured people have rights too. You'd forget it sometimes with the hype and hyperbole around this area of practice. APIL's purpose has always been to fight for the rights of injured people, to campaign for fairness in the law, to prevent needless injury, and to make sure our members are the very best lawyers they can be, and to deliver the best possible service and profitably. Sadly, we have all seen the right to full and fair compensation eroded over recent years, while at the same time injured people are vilified in some media and public forums. The new mesothelioma scheme is a case in point. Why shouldn't people with mesothelioma who are forced to use the scheme because their insurers can't be traced have to give up some of their damages? They would have lost even more if the government hadn't passed on administrative savings into the scheme. Why can't insurers who've taken and invested profits and premiums over the decades do the right thing and pass on some of that profit to ensure these people receive 100% of their compensation? I would suggest it should be socially unacceptable for them even to consider not so doing. To deprive someone of any of the compensation to which he's entitled when he may have only months to live is unconscionable. Political debate during the passage of the mesothelioma bill made it very clear that 75% was about the best deal the government could get from the insurers. This shouldn't be about doing a deal, it should be about doing what's right. As I stand here addressing you in Newport, I'm reminded of the fierce battle going on about who's responsible for asbestos in schools in this jurisdiction in Wales. The UK government says that asbestos management is a devolved issue, while the Welsh government says it's the responsibility of the Health and Safety Executive. Until someone accepts full and clear responsibility for asbestos in schools in Wales, nothing satisfactory will be put in place to manage the situation. That's completely unacceptable. The issue demands a proactive approach rather than piecemeal, short-term reactive approach that we presently have. And it must be a coordinated approach across the whole of the United Kingdom. Organisations such as Asbestos in Schools are campaigning tirelessly on this issue, and we fully support this work. I've touched already on the fact that what I find particularly tough to take is the way justice plays second fiddle to commercial interests. In this, injured people really are at the back of the queue. It seems that being injured, not through some simple accident, but because someone did not take or could not be bothered to take proper care, can make a person a pariah in the eyes of the government, the press, and business, largely, in my view, as a result of the ABI's cynical campaign to undermine the reputation of injured people, and indeed those who represent them. I believe it was a sad day when Lord Chancellors stopped being legally qualified. While there is no doubt that legally trained Lord Chancellors haven't always got it right in the past, I find it hard to believe that a lawyer would have allowed the relentless de facto attack on injured people, not to mention the indifference to access to justice that we've seen over recent years. I also find it really hard to believe that a Lord Chancellor with a grounding in the law would ever countenance the suggestion that court fees should actually generate profit in civil cases, as has been suggested in a recent consultation by this government. I hope this suggestion is allowed to run into the ground. Justice for government profit rather than justice at cost is a line which should not be crossed. The government should be ashamed of itself for even contemplating it. I believe and I hope the worst of the reform agenda is behind us. The time is therefore now right to drive forward in a new gear. Turning to our campaign agenda, I see a number of areas of focus over the coming year. They are deliberately focused on the needs of victims of negligence. We have already made a good start this year under Matthew's leadership, with the launch in Parliament of our campaign to help people who suffer psychiatric harm after the death or injury of their loved ones, a very timely campaign, coming as it does in the 25th anniversary of the Hillsborough disaster. The law, as it stands, puts almost insurmountable obstacles in the way of people who are already suffering so much and need help and compensation to help set their lives back on track. Why does the law only assume that a close tie of love and affection between spouses and parents, children or fiancés is appropriate to make an award? What about brothers, sisters, grandparents, close friends? Why does the law prescribe that the cause of psychiatric injury has to be shocking and that the person who suffered mental harm has to be close in time and space to the incident? Society has developed over 25 years since Hillsborough, as has medical knowledge of mental illness. It's high time the law caught up. A further area of focus is the Medical Innovation Bill devised by Lord Saatchi, which seeks to protect doctors from litigation when they use innovative techniques on their patients. Who could be more vulnerable than some of these patients in the care of the NHS? So how dangerous would it be to remove the protection the law provides for such vulnerable people? The bill is being painted by the formidable Saatchi regime, PR regime, as a way to cure cancer through legislation. Let me be clear that anyone losing a loved one to cancer, and I have myself, deserves with great sympathy and not least Lord Saatchi, but this can't be a passport to bad law. What evidence is there that a cure for cancer has not been found because doctors are so afraid of litigation that they won't use innovative techniques? Doctors are innovating all the time. I'm not aware of a single doctor being sued for failing to innovate. The bill went nowhere, and rightly so, as a private member's bill, but now is the subject of a government consultation and an enormous amount of PR hype. It has captured the imaginations of patients who have no idea that it is effectively a license for doctors to play God. Most patients wouldn't realise there are already many checks and balances in the system to help protect them from any kind of malpractice. The bill appears to make no sense to those informed about the issues involved, whether lawyer or otherwise, on either side of the fence. Yet the government is picking it up and appears to be running with it. We wonder why. We are already talking to others about what we can do to ensure that patient safety is protected through the passage of this bill as far as we possibly can. It's just as important to use our knowledge of claims against the NHS to help in our campaign to prevent needless injury. For example, between 80 and 95% of pressure ulcers can be avoided if simple procedures are carried out by health carers. Pressure ulcers are painful, debilitating, and completely avoidable in terms of human suffering and the expense to the NHS, and yet the level to which this issue is being taken seriously in the NHS varies wildly from regional trust to regional trust. Our campaign will seek to avoid this needless suffering by calling for a uniform and excellent system of care across the country. When the worst happens and people are injured, they must have a fair outcome, and we must continue to fight to put to an end shady and unethical deals which make the injured person doubly vulnerable. APIL's tenacious lobbying efforts have started with others to generate some good results here, and the government appears to have been persuaded at least that pre-medical offers in RTA soft tissue injury cases should be a thing of the past. Our job now is to keep up the pressure and to see this through to the end, as it continues predictably to be resisted by the ABI at every turn. Workers who suffer at the hands of employers who are more interested in profit than the safety and health of their employees are incredibly vulnerable. This is now a greater concern following the introduction of the Enterprise and Regulatory Reform Act. At a time when HSE inspections are subject to swingeing cuts, the Act is a charter for rogue bosses who may be tempted to flout regulations in the double comfort of knowing that they are both unlikely to be prosecuted and that it will now be easier for them to avoid meeting their responsibilities to injured workers under the civil law. We need to start thinking about real deterrents to persuade employers to take health and safety issues seriously, and to understand that a safe workforce is an efficient, motivated one. When employees are injured through no fault of their own, they should have the comfort of knowing they can make a claim without fear of losing their jobs or being placed under pressure by their employers not to claim. Research we've commissioned has shown that 80% of those asked think the system in respect of bereavement damages is fairer in Scotland than in England and Wales. That is, a court assessment of damages as opposed to a very low fixed tariff. It's another issue we have already broached with the government and which we will be developing over the next year and beyond. We must remember too that it's not just practitioners and injured people in England and Wales who are subject to which are far-reaching and potentially damaging reforms. There's lots of reforms going on in our other jurisdictions. Colleagues in Scotland have been involved in a monumental battle against government plans to increase the jurisdiction of the Sheriff's Court from £5,000 to £150,000. I applaud the work that our Scottish members have done to oppose the government's plans. There is so much in the government's plans in Scotland which is supportable and good, but removing almost all personal injury claims from the Court of Session isn't one of them. There are genuine fears that the Court of Session, as the very court which gave us the first instance decision in Donoghue and Stevenson, will effectively end as a court of first instance for personal injury, and that the system which remains will not be properly resourced, leaving injured people again the losers. Last year, in Northern Ireland, the county court limit was increased from £15,000 to £30,000. And we're hearing already that this has decimated the High Court in terms of its quota of personal injury cases. And county court judges are struggling. Injured people and their representatives right across the United Kingdom are facing similar problems. So it's really important that we all learn from each other and that we stand together. Another vital campaign is the promotion of rehabilitation across a range of serious injuries. We must do a lot more to promote the use of rehabilitation and to defend its use in the face of apparently sheep-like attacks from the insurance industry, which sometimes masquerade as support. Early rehabilitation, especially in catastrophic injuries, can make a huge difference to a patient's recovery, which should be what everyone wants: lawyers, insurers, and the NHS. It's certainly what the injured person wants. Rehab obviously costs money, which is why some insurers are so reluctant to proceed. But the prospect of paying less in damages if the injured person makes a good recovery should provide the necessary incentive, even if the prospect of just doing what is right does not. And why should the NHS and local authorities, and ultimately the taxpayer, often end up picking up the tab for rehabilitation when the wrongdoer should pay for it? The recoupment of costs in this field is in need of reform, which is long overdue and is something we will be lobbying for. Rehabilitation in hospitals is designed only to get people to the point of discharge, which is a long way short of full recovery. It can then be far too long before local authorities step in to help, by which time the patient's progress may have stalled. Reform to ensure that the wrongdoer pays to get the injured person back on his feet through a combination of both early rehabilitation and restitution compensation has to be the way forward. With these issues, it will always take time to achieve results. We know that from experience. We also know that it will be necessary to negotiate and sometimes to take things step by step, but we will be resolute, determined, and tenacious. In addition to all these campaigns, which we will now turn our attention, we will, of course, see to the end the work we have been doing to improve the efficiency of our system for bringing mesothelioma claims, to improve medical reporting and diagnosis of RTA soft tissue injury claims, and to develop a system of data sharing to help fight fraud. So let us do what we do best. Let us make sure that our businesses are in great shape so that they can fulfill a truly unique purpose, providing injured people with the very highest standard of professional representation. APIL's accreditation scheme has now been running for 15 years, and we should be proud of it. Only recently it received high praise from the Legal Services Consumer Panel. It is objectively assessed as one of the best accreditation systems available for lawyers who want to improve the way they work and to help injured people recognise the level of service and expertise that they can expect and should receive from every APIL member. It would be great to see every member of this organisation getting involved and committing to raising their professional standards even higher. We won't defend malpractice or practices which are indefensible on either side of the fence. We will pursue without apology the right course for the victims of negligence. We will continue to engage with other organisations with similar interests because we know that together our voices can be stronger. As individuals, we will be the best we can be for the people who need our help, the injured people. Professionalism is not simply about rules and regulations or even compliance. At its heart, it's about integrity, complete commitment, which is never more important than when representing an injured person. We will never cease to make this point at every opportunity. We will also never cease to expose every shoddy agenda which puts profit before people. We've set ourselves an ambitious agenda, and in my experience it will extend further, and rightly so, for this year ahead. But I have no doubt that together we can make great strides. Being a member of APIL is a badge of honour. Let us wear it with pride. Thank you.